For this installment of Washington Legal Foundation's Legally Brief, we're talking with Hyman Phelps and McNamara partner Kurt Karst about antitrust challenges to certain patent litigation settlements between branded and generic drug companies. The particular type of settlement under legal fire are those where the generic company agrees to quote-unquote delay market entry in return for something of value from the branded company. Kurt, in a recent post for the firm's FDA law blog, you called these types of settlements a hot ticket item. Why are they?
Well, Glenn, they've patent settlement agreements, or as opponents call them, pay-for-delay agreements, kind of a loaded term if you ask me. But they've been growing in importance perhaps the better part of the last decade or so, and in fact has involved all three branches of government. There have been several cases over the years, several circuit court cases, and in particular there was a case where the Third Circuit ruled in mid-July of this year that was really a bit of a bombshell for folks. Instead of following several other circuit courts that have adopted a certain test in analyzing these types of patent settlement agreements, the scope of the patent test, the Third Circuit instead took on a new analysis, the quick look rule of reason analysis, and under that analysis, patent settlement agreements are presumptively anti-competitive, and any type of a payment is prima facie evidence that the patents do violate the antitrust laws, unless you can rebut that with data or information showing that the agreement is in fact pro-competitive. This is somewhat similar to legislation that's been introduced in Congress and has been pending for several years now that would make these type of agreements per se unlawful with a rebuttable presumption, however, if you can show that they're pro-competitive. So essentially you had the Third Circuit in this decision involving a product called K-Dur, potassium chloride, between brand and generic companies, adopting this brand new analysis, this quick look rule of reason analysis on an agreement that, interestingly, the 11th Circuit had previously ruled on under the scope of the patent test and found not to violate the antitrust laws. So you now have this interesting circuit split that's been created on the exact same agreement involving K-Dur.
So the Third Circuit decision and the 11th Circuit decision, were the facts significantly different? What was different about the Third Circuit case, do you think, that made them come down in that way and contrary to other circuits?
Well, Glenn, the facts weren't really different. I mean, it's the same agreement that was at issue. I think the Third Circuit just looked at the tests that had been adopted by the sister circuits here and decided, really for the first time, that it would not accept that scope of the patent test where these types of agreements are looked at and determined not to be anti-competitive if the agreement, the exclusion under the agreement, does not exceed the scope of the patent. And looking at this analysis that had been adopted by the sister circuits, the Third Circuit simply said that that's not the right test. The right test is this quick look rule of reason test and applied it.
The Supreme Court has denied cert petitions from losing plaintiffs in drug patent settlement cases on several occasions in the past. What do you think is different with the K-Dur petition that may increase the chances that the justices will take it this time? I should back up. Actually, over the past 8 years or so, the Supreme Court's been petitioned not fewer than 5 times to take up patent settlement agreements and whether or not they violate the antitrust laws. And what is the proper analysis to be applied to these types of agreements in the Hatch-Waxman space? And each time the court has denied certiorari. This time, however, we have a clear circuit split between the Third and 11th Circuit on the same agreement, same drug. So we seem to be at a point now where if the Supreme Court is ever going to take it up, this would certainly seem to be the case where they would take it up. In fact, there have already been now, of course, 2 cert petitions filed by both Merck and Upshur Smith Laboratories in the case. So we'll find out in time whether or not the Supreme Court does agree and says that they do need to resolve this issue now. It's ripe.